The Supreme Court decision in the case of Manantan versus Court of Appeals. On the first issue, petitioner opines that the Court of Appeals should not have disturbed the findings of the trial court on the lack of negligence or reckless imprudence under the guise of determining his civil liability. He argues that the trial court's finding that he was neither imprudent nor negligent was the basis for his acquittal, and not reasonable doubt. He submits that in finding him liable for indemnity and damages, the appellate court not only placed his acquittal in suspicion, but also put him in double jeopardy. Private respondents contend that while the trial court found that petitioner's guilt had not been proven beyond reasonable doubt, it did not state in clear and unequivocal terms that petitioner was not recklessly imprudent or negligent. Hence, impliedly the trial court acquitted him on reasonable doubt. Since civil liability is not extinguished in criminal cases, if the acquittal is based on reasonable doubt, the Court of Appeals had to review the findings of the trial court to determine if there was a basis for awarding indemnity and damages. Preliminarily, petitioners claim that the decision of the appellate court awarding indemnity placed him in double jeopardy is misplaced. The Constitution provides that no person shall be twice put in jeopardy for the same offense. If an act is punished by a law and an ordinance, conviction or acquittal under either shall constitute a bar to another prosecution for the same act. When a person is charged with an offense and the case is terminated either by acquittal or conviction or in any other manner without the consent of the accused, the latter cannot again be charged with the same or identical offense. This is double jeopardy. For double jeopardy to exist, the following elements must be established. A first jeopardy must have attached prior to the second. 2. The first jeopardy must have terminated. And 3. The second jeopardy must be for the same offense as the first. In the instant case, petitioner had once been placed in jeopardy by the filing of criminal case number 066, and the jeopardy was terminated by his discharge. The judgment of acquittal became immediately final. Note, however, that what was elevated to the Court of Appeals by private respondents was the civil aspect of criminal case number 066. Petitioner was not charged anew in CA-G.R. CV number 19240 with a second criminal offense identical to the first offense. The records clearly show that no second criminal offense was being imputed to petitioner on appeal. In modifying the lower court's judgment, the appellate court did not modify the judgment of acquittal, nor did it order the filing of a second criminal case against petitioner for the same offense. Obviously, therefore, there was no second jeopardy to speak of. Petitioner's claim of having been placed in double jeopardy is incorrect. Our law recognizes two kinds of acquittal with different effects on the civil liability of the accused. First is an acquittal on the ground that the accused is not the author of the act or omission complained of. This instance closes the door to civil liability. For a person who has been found to be not the perpetrator of any act or omission cannot and can never be held liable for such act or omission. There being no delict, civil liability ex delicto is out of the question, and the civil action, if any, which may be instituted must be based on grounds other than the delict complained of. This is the situation contemplated in Rule 111 of the Rules of Court. The second instance is an acquittal based on reasonable doubt on the guilt of the accused. In this case, even if the guilt of the accused has not been satisfactorily established, he is not exempt from civil liability, which may be proved by preponderance of evidence only. This is the situation contemplated in Article 29 of the Civil Code, where the civil action for damages is for the same act or omission. Although the two actions have different purposes, the matters discussed in the civil case are similar to those discussed in the criminal case. However, the judgment in the criminal proceeding cannot be read in evidence in the civil action to establish any fact there determined, even though both actions involve the same act or omission. The reason for this rule is that the parties are not the same, and secondarily, different rules of evidence are applicable. Hence, notwithstanding herein petitioner's acquittal, the Court of Appeals, in determining whether Article 29 applied, was not precluded from looking into the question of petitioner's negligence or reckless imprudence.